evening, everyone. My name is Bushe Sibanyoni, and I'd like to welcome you to our Legal and Tax Workplace webinar. I am joined today by three lovely ladies who happen to be very experienced and qualified legal experts. I'd like to welcome Nadia Hadebe, Kayagazi Makunga, as well as Natasha Ngwirume. Welcome, ladies.
Thank you. Hello.
Thank you so much for joining us. So today we'll be discussing some common workplace challenges that most employees face, on a daily or very routinely basis. We'll be touching on areas such as unfair labor practices, dismissals, as well as arbitration proceedings. But before we get started, there are some house rules that I'd like to set out. First of all, I would like for us to reserve all questions for the end of our discussion, where we'll have an open Q&A session. So you'll be able to ask and address any questions there. Secondly, if you want to comment or have a question, we have a live chat feature that's available. So feel free to type out your question. And I'd like you to be open and feel relaxed and free, this is a platform. We have a very qualified team of legal advisors, and they're at your disposal to pick their brain and get clarity on any sort of issues that you might have. Okay. So firstly, in this webinar, we'll be touching on the retrenchment process, and we'll have one of our legal experts take us through the process and help us to understand the procedure, as well as how to facilitate a retrenchment, especially during this uncertain period of COVID-19 and the lockdown that we were entrenched in. Secondly, we'll be looking at an employee's entitlement to annual leave and sick leave, and just to understand whether it's merely just a privilege that's offered by an employer, or is it within your rights to actually acquire leave on an annual basis. And then lastly, we'll be looking at the CCMA process, where I'd like to understand more about the role of the CCMA and to understand what your rights as an employee are and what the CCMA can and can't do to actually assist an employee. So firstly, we're all looking forward to the festive season, and hopefully we get to go on holiday, we get to have some time off to spend with our families. And the first question that I would like to address to you, Nadia, is what are my rights, and what is my employer? Am I entitled to an annual leave or sick leave? And given this COVID-19 lockdown period, can my employer actually cancel my leave because maybe I wasn't working during the lockdown period? Can you just take us through that process?
Okay, first of all, we all know that we are entitled to annual and sick leave, but we need to understand how it is calculated. So I'm just going to be simple, in simple terms. If you work one complete month, you get 1.26 days of leave. So that those leave days accrue to your December. So as you're pointing out, it's December, you want to go on holiday. So your employer does have the discretion for operational requirements that are in the best interest of the business to say, okay, this is how we're going to plan the leave. And he can cancel the leave if it's going to jeopardize his business, but he needs to give you notice as well.
Okay, cool. And how many annual leave days am I entitled to in a certain period, as well as how many sick days am I entitled to?
Okay, let's start with the sick. The sick days for every 36-month cycle, that's 3 years in total, okay? You get 30 days. And with your annual leave, you are entitled to the days that you accrue. As I mentioned earlier, if I work 1 month, I get 1.26 days. And each month I work, it accrues to a total balance of leave, which is the annual leave, vacational leave.
Okay, cool. And what if my company was shut down during the COVID-19 lockdown? Will my days be accrued, or is it just a matter of me losing out on my leave?
Okay, remember, with the pandemic that we are facing with COVID, it's no one's fault. The government has put the lockdown and everybody to stay indoors. So it's not your fault. So during that time, your leave days can accrue.
Okay, great, great. And then in the event that I may be contracted COVID-19, whether it be at work or in a personal capacity, what do I claim for? What is my recourse, and where would I need to go, or what to do?
Okay. If you contacted the virus at work, so you can treat it as injury or duty, you can claim it from the Workmen's Compensation Fund. But if you didn't contact it at work and you still got the virus, then what will happen is now they will your company, your employer has to go and do an application to the Temporary Employment Relief Fund to get for you your funds so you can balance out the money.
Okay, great. And then in a situation where someone was able to work, like most of us within legal and tax were working from home, is that kind of, are you asking for too much if you now want to have an annual leave and take maybe a week or two off during December? Because I personally am in that predicament. I feel that, because I was at home, it's asking for a bit too much, but I was working. So what are the rules, and can I still get my December leave?
Remember, your leave still accrues because you were working, so the no work, no pay principle won't affect you. And it was COVID, you were at home due to COVID, so it will accrue it. But again, your employer does have the discretion when it comes to operational requirements, who to allow to go to leave and who to say which leave to approve and which leave not to approve.
Okay, great stuff. Now, what happens if my employer does not follow the correct process? KK, I would like to know from you, what is my recourse from that?
All right. So if your employer doesn't follow the correct processes in terms of maybe making those applications for you, you can then report the matter to the CCMA if it's an unfair labor practice that they didn't follow process in terms of making those applications for you. However, if it is now, salary related, that they didn't pay you in that way, then you would have to report that matter to the Labor Department as a salary complaint.
Okay, great stuff. And KK, for those that aren't aware what the CCMA is, can you explain what the CCMA is and what role it plays for both employers as well as employees?
Okay, so the CCMA, that's the word in short, is the Commission for Conciliation and Arbitration. It's an independent authority for dispute resolutions, right? So they also provide advice and training on labor relation matters and also resolve disputes. So we must always remember that the CCMA is not only meant for the employee, but also it can adjudicate over matters relating to collective disputes, which is agreements between companies and all of those things. So it's not only meant for the employee, but also for the employer as well.
Okay, great. And what sort of disputes can the CCMA adjudicate? Can you give us some examples of how I could use the service?
Okay, so the CCMA will take matters for unfair dismissal, unfair discrimination, as well as unfair labor practices. For example, your promotions, unfair promotions and unfair demotions, as well as suspensions. Yes.
Okay. And what sort of disputes can the CCMA not assist with?
Okay. So the CCMA will take disputes between employees. So it won't take disputes between independent contractors who work between each other. And it won't take matters for disputes for collective agreements, matters that can be adjudicated over by the bargaining council. The CCMA does take retrenchments where they involve an individual, but it won't take retrenchment matters where it involves more than one person. However, where it does involve more than one person, the CCMA can mediate between the parties, but if the mediation fails, this is now a discussion between the parties to try and resolve the matter amicably. So if the mediation does fail, even though it's a dispute between these parties, then it will be then referred to the Labour Court for arbitration, which is a more formal process.
Okay, so even if I am a part of the bargaining council or a collective, there is a chance that my case could be reviewed by the CCMA.
Okay, so if you do form part of a bargaining council, you would need to report your matter to the bargaining council because they also are the dispute resolution body. But if you don't, you can refer the matter to the CCMA if you're not part of. Yeah.
Okay, great. And are there any time limits for lodging a complaint?
Okay, there are strict time limits when it comes to reporting a matter to the CCMA. Like I mentioned, that you can refer an unfair dismissal. You would need to do that within 30 days from the date of the dismissal. If it's an unfair labor practice, your suspension, promotion, and demotion, you would need to report it within 90 days from the date of the occurrence. And when it comes to unfair discriminations, then you need to report that to the CCMA within 6 months, right? This would include, you would need to, in your calculations, include your holidays and your public holidays as well as the weekend. Yes.
Okay.
If you fail to refer your matter timelessly, then you'll be out of time. You basically have to make an application for condonation. That's what we call it when you're asking the commission to hear your matter, even though you are outside of the time limits. Then they will hear you out for reasons for the delay. And if they consider them reasonable, then your matter may be set down.
The matter. Okay.
Yeah.
Great stuff. And then if not, then your case is merely thrown out. Will that be the case?
Basically, if the commission does not accept your application, then that's the decision that they will have made. You can make a review application with the Labour Court, however, to review the decision that was made.
Okay, great stuff. KK, I'd also like to know from you. I've heard a lot of different sort of stances on this, and I want to clarify it. In terms of having a representative or a witness or an attorney present during your hearing, what are the rules around that? Is it something that is allowed? Can you take us through that? Because as I said, I've heard very different opinions and stances and experiences. So I just would like to clarify that.
I can imagine. We do try at Legal&Tax to try and clear the role that the commission plays. So when it comes to you having reported your matter to the CCMA, you are met with 2 stages there. The first stage is conciliation, and then the second stage is arbitration. So this first stage is a mediation. This would mean that the commissioner is listening to both parties to see whether or not the matter can be resolved amicably, as I mentioned earlier. So at that stage, no attorneys are allowed. Right, so each party attends on their own, and the commissioner tries to mediate between them. And now the commissioner does not have power to make a decision at this juncture, because it's a decision that will be made between the parties if they agree to whatever offer is being made by either party. So no attorneys allowed at the conciliation stage. So if parties reach an agreement, for example, at the conciliation, then a settlement agreement will be signed about how they agreed, and that's where literally the matter would end. You would not be able to challenge the matter any further. So if the parties don't come to a resolution there, then the matter would then be referred by the applicant or whichever party is disgruntled for now arbitration process, the second stage that I mentioned. And at this stage, attorneys may be allowed. Okay, in some matters, they don't automatically allow attorneys. So the attorney would make an application to have them present at the hearing. Yeah. For example, in misconduct matters, you know. Yeah.
Okay, great. And now, if my employer, is fighting me, in terms of paying for my accrued leave, for example, because of a case of no work, no pay, what should I do in that situation? What is my recourse
if you could repeat the question,
in terms of escalating it maybe to the CCMA?
Yes, please start over, but I didn't get the beginning.
So looking back to your entitlement to leave days, and if I've accrued leave days, but my employer declines to pay me my settlement for the leave, what is my recourse? Can I escalate that matter in order to get my money paid out?
So you can escalate your matter to the CCMA as well if it is a right of a problem with the rights that you have to your leave payment, but it would, however, depend on the amount that you'll be claiming from those leave days. So, for example, the CCMA takes the matters for right of for the right, but then the Labour Department would take your salary matter if you have a problem with the way that the salary was not paid, rather. So the Labour Department would take your matter if your the amount that you're claiming is below 205,000 there, but they won't take your matter if you're also like a senior at your workplace. So the CCMA can take matters of that for the lack of a better word, limit of the amount of the salary, but then they will also take if you are a senior. So it really does depend on what your matter is, and how much you claim.
Okay, cool. Cool. So, I mean, we are all aware of the economic climate at the moment due to the pandemic we've been through for the last few months. And now with the COVID-19 pandemic, a lot of people have found themselves in a situation where they've lost their jobs. A lot of industries have suffered. A lot of companies have closed down. Unemployment rates are increasing on a daily basis. And a lot of people have been faced with retrenchment. And I just would like to understand, Natasha, what is retrenchment and when does it occur?
Okay, with retrenchment is based on the Labor Relations Act, more specifically Section 189. And with retrenchment, it comes about when the employer contemplates dismissing the employees. But remember, it's a no-fault dismissal on the part of the employee, meaning that they haven't done anything. But unfortunately, due to the operational requirements, the employer has had to let some of its employees to go. Operational requirements are mostly based on three requirements. For example, the economic, and then there is structural, and there is technological. I'll explain all three. With economic, for example, I'm going to use, let's say, the construction industry. All industries were shut down, but I'll just pick on the construction industry. With the economic, what happened would have been that they were not able to carry out their projects. Their clients were not then able to pay them because no work was done. And with that, there's no money coming into the company. And as a result, the employer has no finance and has to let go of the employees. And then when it comes to technological, that's when it refers to machinery, for example. If the employer has bought, for example, with the construction industry as well, an excavator, which is going to dig trenches and roads, there's going to be no need for the employees that were digging roads and everything. So at the end of the day, what's then going to happen is they're going to let go of those employees that were digging the roads, using the shovels and the picks, because now they're replacing them with the excavator. That's for the machinery part, the technological part. And then we have the structure as well. When the employer realizes that, to make more profit, I need to reduce the employees that I have. They'll restructure it, which means if they had 20 employees, now they're going to have 15. So they need to, unfortunately, let go of 5 so that they get maximum profit and restructure everything. And some positions are then made redundant. There's no longer any need for them. So that's the structural part.
Okay.
And then when it comes to retrenchment, what also needs to happen is when they've contemplated this retrenchment, they need to give in a notice, which is in terms of Section 1893.
Okay.
It is given to the employees, and also to the unions if the employees do have unions, a representative.
Okay.
And in this notice, what then happens is they're going to specify the reasons why they're going to do the retrenchment. For example, for the operational requirements, and also in that notice, they're going to explain the severance package. They're also going to specify, or they're going to also invite them to come into the meeting where they can find ways to actually avoid the job losses.
Okay.
And with this consultation, it's supposed to be a meeting of the minds. Both sides need to come in with ideas, and both sides need to listen to each other. Representations need to be done, but they'll be done in writing, and the employer needs to also respond in writing when it comes to the notice.
Okay, great. And can an individual find themselves in a position where they are forced to accept the retrenchment, or almost, backed into a corner? I've heard of the two different terms, voluntary and involuntary retrenchment. Can you enlighten us on that? Can it be a forced ordeal where you have no other choice but to accept the settlement?
Okay, after the consultation, what normally happens is with the voluntary one, the employer will speak to the employees. Once they've identified the employees that they want to leave the company, that will be dismissing, so to say. They will then ask if there's anyone who would love to take a voluntary package. And with this one, what will then happen is they'll give an incentive as to why you can accept it. With the legally, what happens is when it comes to a severance package regarding the voluntary retrenchment, when it comes to a severance package, legally it is 1 week's salary for every year worked. So the employer will then give more benefits to these employees to say, look, rather take the voluntary package, there are more benefits to it. And once the employee does that, they've waived their rights to go to the CCMA or the bargaining council and say that, look, I was unfairly retrenched. The moment they accept it, but it comes with a lucrative package as well. And then when it comes to the involuntary one, once all consultations have been done, exhausted, unfortunately, for example, let's say the company says we want 10 people to go. And for the voluntary package, they invite employees to come and they get 7 who are going to voluntarily take the package. They still have 3. And then they will advise that, okay, we only 3 now need to go. Unfortunately, they'll then be given the letters and told, now we have decided there is no other choice. There are no other jobs that we've tried to avoid the job loss. We've tried to avoid letting you go, but unfortunately, there's no option. So A, B, and C, these are the letters.
Yeah. Okay.
That's it. Yes.
Okay, cool. And KK, can I refer a retrenchment case to the CCMA? Do I actually have a leg to stand on? Can you kind of paint out the different scenarios where I could actually refer the case to the CCMA?
Okay, so retrenchment, sometimes it may be that the one person's position became redundant and not necessarily numerous people. So you would be able to refer a retrenchment where you are the only person being referred to as redundant. If the employer, however, did not follow process, as mentioned by Natasha, that there are processes that need to be followed. So if the employer fails to follow those processes, then you can refer it to the CCMA. However, if it does affect more than one person, then the CCMA can hear it for mediation purposes. This is the stage for conciliation I mentioned earlier on. So they would hear if the matter can be resolved between the parties, and if that mediation fails, then the matter would then be would have to be referred to the Labour Court for arbitration processes. However, they can report it to the Labour Court directly.
Okay. Okay, great. Back to you, Natasha. I would like to understand what your kind of description for a fair retrenchment would be. what due course needs to happen in order for it to be a fair retrenchment?
Okay, with that, we start with the notice that I referred to
And
earlier.
what is that notice, the notice period?
Okay.
Well,
Okay.
sorry, yes.
Okay, for it to be a fair retrenchment, it all starts with the notice, the section 1893 notice, which is going to lay out the criteria for the retrenchment, the reasons for the retrenchment, inviting the employees or their unions to find ways around avoiding job losses. And then there will be consultations. But what you need to take note of is an employer cannot just give a notice and say after 2 weeks of consultation, then the retrenchment process is over and done, and we are now dismissing your retrenching when that's it. It takes between 30 to 60 days. It all depends on the number of employees that are being retrenched. So it's going to be 30 days to try exhaust everything, alternatively 60 days. That's for it to be fair. And for it to also be fair, there needs to be a meeting of the minds. All parties involved need to discuss ways forward. And also, it is encouraged that employees and the union reps should not try frustrate the process as well as the employers. But it has to be a meeting of the mind. Just because you're just checking the tick box in terms of section 189 doesn't mean that everything is fair. It has to be fair and reasonable as well. And also remember, when it comes to the criteria that has to be stated in the notice, there are normally two of those that are deemed to be fair. The first one is the is the last in, first out. That one is deemed to be fair. And then the second one, but with the second one, employers need to be extremely careful, and they do need to give reasons as to why they're selecting that process. And for that one is the first in, first out. So they do need to explain things like it's because of the experience, the expertise, the performance. They need to justify why they're letting someone who's been there, let's say, 15 years go first, and leaving the one that's been there 5 years or something along those lines. So those are the criteria that also make it fair.
Okay, great stuff. And would you say that an employer is liable for assisting the employee in acquiring a new job or position? I've heard of cases where they may need to give them time off from work in order to attend interviews, for example, or just offer them some sort of resource in order to assist them in acquiring a new job. Is the employer actually liable for that employee?
No, they're not. But what we've seen in some cases, an employer in the letters that they give their employees once they've been retrenched, they will state things like, should we get back to being viable economically, or if we've got an open space, we'll think of you first. If this happens within 6 months, they can state that. They can also offer to get a position in a sister company they can offer to look for a job for the employee in a sister company, but they're not obligated to, but they do try by all means to help the employee.
Yeah.
As well as to tell them, look, yes, because of the economy, we know it's hard. We can actually, instead of coming in your 5 days, we'll still pay you your notice pay, we'll still pay you your severance package. Instead of coming in 5 days, you can actually go and start looking for another job, or you don't need to wait the notice period. They can do that, but it all depends on the company structure as well.
Okay, so it's at their discretion 100%. Because I mean, we could all use a helping hand, especially in that situation. I mean, I can't even imagine. It's devastating to be out of a job and not have any prospect for a new job, especially during this period, So, okay, great. Nadia, can you explain what is due to me in terms of my notice pay? and leave if I ever am retrenched?
When it comes to your retrenchment, and then you have like a month's notice period, so you're going to get what you worked for that month. So you're going to get your salary for that month. And when it comes to calculating your annual accrued leave, that's where human resource will come in, and they'll calculate all your balance accrued leave. But again, we must take into account when you come into the question of my accrued leave. With the law says you get all the leave that you have accrued, but there are some companies that sign different policies. The policy might say that no, if for this first 21 for your first 21 days leave within the 12 months of your consecutive 21 days, you get those 1.26 for each month. If you do not exhaust it in that cycle, then it cannot carry over, you abandon it, that sort of a thing. If that policy is in place and you signed a contract with that, then that will override you getting all, say if you are retrenching and you have maybe 50 days accrued leave, but some of those 50 days are coming from other cycles that you've worked, the 12-month cycle. So HR has a policy that says that you abandoned your leave, then that will override. But if there's no policy, all what is accrued to that date will be due to you.
Okay, great. And KK, what is my recourse then if that money is not paid to me? What is my next plan of action in that situation?
Yes, the matter can also be referred to the Commission for Conciliation and Arbitration, depending on the amount that you'd be claiming from the employer, or you can report to the Department of Employment and Labor. Then they will appoint an inspector who will then continue to investigate into it and issue a compliance order in terms of what should happen, and the employer should comply as per the order.
Okay, great. Okay, so I see that we do have some questions from our guests. The first question, which I will pose to you, KK, what is the maximum amount that one can claim for an unfair dismissal via the CCMA?
So when you've reported the matter to the CCMA, would obviously here, because as we explained earlier, that there's processes to follow in order for one labor matter to become fair. So it may be automatically unfair once the commissioner sees it. So the commissioner at the arbitration stage, remember that he is the decision maker at the arbitration stage. So if you're claiming a specific amount that you're not agreeing with the employer at the conciliation stage, then the commissioner can either order re-employment, reinstatement of you into the workplace, or remuneration, which is compensation. So they may order up to 12 months for an unfair dismissal of your salary, 12 months payment of your salary. But if it's maybe an automatic unfair dismissal, then they may order up to 24 months.
24 months.
Salary payment.
Okay, cool. The second question I have from an anonymous guest is that they have a problem with their employer placing them on layoff without consultation and then extending the layoff again without consultation. What do they need to do? Natasha, can you address that, please?
Already legally, that's already an unfair layoff, because at the end of the day, like I did mention, the employer needs to give notice and consult with the employee, alternatively the union. So if they do have a union, they would need to also find out from the union if the employer did speak to them or not regarding this layoff. If they don't have a union and the employer didn't speak to them, it's already unfair, and they can go and open a case at the CCMA or bargaining council, depending on the industry of employment. And it is already an unfair labor practice as it stands, and they have about 90 days.
Okay, cool. And then there's a second sort of aspect to this question. So he says that I'm also on layoff without salary and banks don't accept layoff letter for payment break. So what needs to be done in that kind of situation?
Okay. With the salary, so there was no okay, sorry, can you come again with your question? There is no
They say
consultation.
that he's been put on layoff without a salary, and the banks don't accept a layoff letter in order to acquire a payment break. What does he need to do in that situation?
Okay, with that one, what I would strongly suggest is he does contact us so that we have a look at the wording of what the letter is saying. And then we can contact the employer for that part, because it's going to now go down to what exactly will the bank accept and what is being stated in that letter. We do need to have a look at it before we can respond.
Before you can respond. Okay, great. Great. So the third question is, I worked 4 hours from the beginning of COVID-19 level 5 right up until level 1 and was paid part of the hours I worked, and my full salary was substantiated by TERS. The employer agreed to pay the difference later on, but he said at his own discretion. Now he says he owes no money at all. Nadia, maybe you can shed some light regarding that scenario.
The conversation specifically between the employer and the employee, was it reduced into writing? Because if it's an agreement between them that this is what we're going to do, I'm going to pay you the difference again, then you can go to the CCMA or the Department of Labor for your salaries issue and say that this is unfair. But if you cannot prove it, remember at the time with TERS is there to substantiate where the employer cannot. And if he got the money from the TERS and substantiated with the rest of the salary, then that's quite fair.
Okay. Cool. Another question posed to you, Nadia, is if one has acquired too much leave and the employer chooses to buy out the leave, do I have a right to refuse the selling of the leave days?
Again, it's your policy in every company. Some companies do have a policy where you can sell off your leave days that have accrued, because remember, HR is there to make sure that the balance is always there and maintained by the company with everybody's leave days. So if they say that they want to sell the leave to you, want you to sell your leave to them, and they will purchase it, and it's in your policy, your company policy, then you can. But if it's not, then you have the discretion to say yes or no, or I would like to accrue it as per my right, as per the labor law.
Okay. Okay, great. I think another one to you, Nadia. Can employees claim from UIF if the employer says workers must work 2 or 3 days in a week and is willing to pay them half their salary? The employer says some contracts have been cancelled and has no money to pay the full salary. So can they claim from UIF if they've been, I guess, put on short time?
The UIF, the unemployment scheme the government did say that they will make provisions for those that do not qualify for UIF, taking into consideration the latest case law revolving about domestic workers where they were not working full time and they were not contributing to UIF, but they still were able to claim. So you have to visit the Department of Employment Services, and they can consider your claim as well, because that's what's currently happening for those, because they were found that some companies were deducting the UIF, but it was not going to the fund.
Okay. And looking at the December season, where most companies go, they have a total shutdown during December. Does that period have to come off my acquired leave days? Is it mandatory that I use my leave days during that shutdown period?
Okay, some companies, what they do is usual practice is they tell you that we do shut down during the festive season, and during the festive season, the 10 days from your accrued leave, you must have 10 days so you can go on leave, and it comes out of your annual leave. So that's allowed. Again, we need to look at your company policy, but generally, if your leave has accrued and there's no policy saying that your leave should be taken, then your leave can accrue.
Okay. All right. And then another question is, can a medical doctor backdate a sick note? So if an employee goes to the doctor today, can then a doctor book an employee from yesterday?
His note should explain why you are sick today, because if he cannot date his notes for yesterday's date, it has to be today's date that you've seen him. He needs to explain, yes, you have been experiencing symptoms from previously, but you saw me today, because the note needs to explain why you're not at work today.
Okay, cool. Natasha, this attendee would like to know what happens if a company gives you a 5 months fixed term contract, which they renew, and then at the end of the renewal, they tell you that they don't have the money to pay, and they end up advertising the same position as a full-time position. Are they allowed to do that?
Okay, normally what happens with fixed term contracts, it is for a certain period, and the employer cannot then just dismiss you before that period has ended. And whereas now they're advertising that position, that's already unfair, an unfair dismissal on its own. But we'd also love to see those documents, but it would be an unfair dismissal from what has just been explained.
Okay, but you would need more information in order to resolve the situation.
Yes, definitely, yes.
Okay.
And see the wording and everything, yes.
Okay. And then if an employer deducts from someone's provident fund, but while they don't hand over the money to the fund, what kind of steps can the person take in order to sort that situation out?
Should I answer?
Yeah, go for it.
So if they're deducting your pension fund monies and it's not going to the correct pension fund as agreed, then you have to go and consult the pension fund adjudicator. Yes. So they will take out a determination. A determination is a ruling as to how the money needs to be paid back to you. And then you can consult your legal representative or do a letter of demand to demand that money, that specific amount from your company. So your company pays it into the pension fund so you can be paid. So in your documents, you'll be citing not only your company, but also the pension fund as well.
Okay, cool. And then another question around leave. If you have not used your leave days and they happen to lapse into the following cycle, but you are not in a position to actually use your leave days because of the nature of the job and the demanding projects, what recourse can you take there?
You can claim payment for the leave days when you retrenched or your contract is terminated, because Section 40 of the Basic Conditions of Employment Act does say that once a contract is terminated, an employee is allowed to claim all accrued leave, unless there's other policies of abandoning leave.
Okay, great. And then we had a few other questions that were posed, not necessarily regarding our discussion, but someone would like to know, is it lawful for waiters in the restaurant industry to only be earning tips and not be given a salary by the employer? Kaya, KK?
Yes. So you obviously have signed a contract in terms of how your employment and remuneration would go. So it also depends on the contract. We have the Minimum Wages Act, which stipulates that wages should be 20 Rand per hour. So the employers have tried to make applications to try and reduce this. So it really does depend on your contract to what you've agreed on. So if you to the fact that you will only be earning as per the tips, then that's what will happen.
Okay, cool. And then we have a question also. Someone wants to know if it's possible to resign while they're on maternity leave.
Yes, resignation, we must remember, is a choice that you make, right? So no one can force you. It's your decision. So you can resign when you are on maternity leave. You may have maybe applied for UIF for maternity leave. So because when you've resigned, you're not entitled to claim UIF. So the UIF may stop paying from the time that you resign. So
Okay.
yes, you're right.
You can. Okay, great. Is there any other enlightening information that you would like to share with us, ladies? The platform is yours. I mean, we are here to kind of take it all in, you know? So is there any other info that you think is important for our guests to be aware of, especially leading up to the December period, leading up to where we are expecting bonuses, for example? We are all looking forward to our bonuses. Is it an entitlement? You know, is it something that is due to us, or is it just merely a luxury and a privilege?
When it comes to bonuses, we need to consider about the current pandemic and the companies, how well are they doing financially. If your
Yeah.
company can still pay your 100% bonus, hoo-ha to you, well, you are lucky. But sometimes the company can just afford that bare minimum and give you that percentage of your bonus. It can be fair at that time, because we remember we are facing this COVID. Some companies were not doing that well. If they were operational, but they were not doing that well. So
Yeah.
it can be so fair that it's a luxury to you if you get your bonus and your full bonus, or you get even a certain percentage. It is a luxury. Yes.
Yeah. Okay.
And
So unless it's maybe stipulated in your contract, you can't really expect it from your employer. Correct.
Even if
What, yes, what
sorry,
happens? Yeah.
if it's in your contract and you get it automatically and it's not discretionary, so you have to get it automatically. If the company is not doing well and your employer will come to you and say to you, can I just hold on with your bonus? Can we get into an agreement to hold on with your bonus due to the company not doing financially well? That's an explanation I believe the CCMA would take, even if you go and say, I'm going to take it for unfair labor practice. The commissioner presiding on that, they will also consider this as being reasonable, because we all know how COVID has affected us all.
Yeah, no, most definitely. I think we're so grateful to still have our jobs and still be in a company, you know, and not have been affected. I think it's such a blessing, because a lot of people aren't as fortunate, you know. And, you know, also looking at the possibility of an increase. What is your entitlement there, and what happens if your employer refuses to pay an increment or offer you an increase?
Okay, I'm judging from this current situation that we are in COVID. We all know that the lockdown started way before the financial year could kick in, and for us to have that discussion with our employer. So when it comes to increases, what is affordable, what is financially, what is human resource coming up with, finances coming up with at the company to say, this is our bare minimum, this is our financial margin at this point in time, and this is how much we can afford. We probably could review you next year. All that is reasonable at this time. What it was normally before the pandemic, and what are we now? It's out of our comfort zone. It's the new norm, I would rather say.
Okay, fair enough. We have another question in. What should I do if my employer refuses to pay sick leave for a COVID case?
I believe if your employer is refusing to pay your sick leave and you have your medical note, you follow the company procedure into saying why you are not at work, you report it to the correct personnel, then you can bring your matter to the CCM or the Department of Employment Services for, again, unfair labor practice, and also claim for the monies that you have been deducted from your salary.
Okay, great. Now we have a lovely comment that's just come in from one of our guests. He says, I personally appreciate this session. It is very informative to both employee and employer. Thank you very much. Yes, the recording will be available later for future reference. We'll post it up on our Facebook page. Thank you so much for such a lovely comment. You ladies have been amazing. And lastly, as I said, is there any additional info that you'd like to share with us?
Basically, just relate to everyone that, the employer-employee relationship is based on trust purely, and things don't always go the way that we would like to go, and lawfully as well. So it's important to always have discussions with your employer about your position and all those things, instead of maybe reacting arbitrarily to whatever is happening. So communication is very important. If there's any issues, you can always come to us at Legal&Tax for advice as we speak.
Nice one. Natasha, what are your parting words for us?
Okay, it's just to repeat what Kayagas has said. When it comes to an employee and employer relationship, respect is also needed both ways. And do not react when an employer says wrong stuff. Call us and discuss the issue with us. Yes, it's a trust relationship, and you need to don't be in a fighting spirit with your employer or your employee. That's all I can say. Just come to us. And oh yes, don't sign documents before you call us, please. If you can, ask for more time before you sign them. Contact us, because the moment you sign anything, there isn't anything anyone can do for you. The moment you sign the dotted lines, there's nothing anyone can do for you. So please call us before you sign any documents.
Okay, great stuff. Before we wrap up, I see another question or two has popped in. Can we address it? What is the procedure for injury at work?
So when you're injured at work, you'd always obviously have to immediately report that to your employer, and then they would then be the ones to assist you with claiming from the workers' compensation. This would only happen if you're injured at work, right? So they would need to report it to the Department of Employment, lodge your claim within 12. They would need to do this claim within 7 days, but your claim can be done by yourself within 12 months. So they would submit your first injury report from the doctor, which would then be submitted to the department by the employer. Obviously, then the department would be the one to assess your claim, the extent of your injuries, whether or not they would be accepting liability to pay out or not. So basically, that's the process. They would have the determining powers whether or not you get compensated for your injury.
Okay, great. And Nadia, your final words?
Let's just be grateful and don't take anything for granted, because looking at COVID, it has done a number on all of us. So if you got your job, just stay positive. As the ladies have just also mentioned, come to us if you have a question. Know your policies at work, know your code of conduct. Understanding, communication, and respect is the key.
Okay, great stuff. Thank you so much for joining us, ladies. It's been such a pleasure. It's been such an absolute pleasure. I've learned a lot. I'm sure our guests have definitely learned a lot as well. You've shed a light on a lot of different issues and challenges that anyone could experience at any given time. So I appreciate your time. I appreciate your knowledge and your company, because you're all so beautiful. I'd also like to just send out a huge thank you to everyone that was involved in putting this webinar together. Thank you to our guests and our attendees for taking the time out of your busy schedules to be with us this morning. I really appreciate it. We thank you. And, with Legal&Tax, we seek to be a companion to all our members and all our clients. We really do care, and you're not alone in any matter. I would like to urge you to reach out to us if you do have a situation that you are struggling with, whether it's a work-related issue or any other personal matter. We are available. We have qualified advisors and legal experts, as you can see. So your matter will definitely be in good hands. I would just like to say, if you would like to make contact with us. We have a very, very visible social media presence. You can find us on Facebook, on LinkedIn, on Twitter. You can also call us on 0860 587 587. And we definitely will get an advisor to settle your query and to assist you. But thank you so much to everyone. It's been amazing. I hope to see you soon, ladies. I know this is a series that will be ongoing, so you'll get to see our pretty faces again in the near future. But for today, I thank you all for your time, and I hope you have a lovely day. Thank you.
Thank you, everyone.
Thank you.
Cheers, guys.
Bye.
Bye-bye.